Namaste, Jai Hind, ladies and gentlemen, and this is a very, very special broadcast, ladies and gentlemen. A struggle that has gone on for 566 years. It's perhaps the longest legal battle that went on, where a deity had to fight for his own Janmabhoomi via the bhaks, the devotees. And as this countdown for the Pran Pratishtha continues, ladies and gentlemen, in this very special effort, what we're going to go through is the legal struggle. Try to chronicle the legal struggle, not just before partition but after partition, who all pushed for it, and at what all stages, how the effort was to stall. Was there a certain level of virtue signaling? And at what point did Ram Bhakts or those who are representing Ram Lala Virajman believe that they will get justice or there is perhaps closure in sight? We'll try and revisit all of this with a very, very special panel. Some who have been part of this legal struggle, others who have followed the legal struggle and have also, sitting on the sidelines, witnessed what they believed is nothing but travesty. Let's go straight across to them and we'll get them to do the talking. From the far corner, advocate in the Supreme Court, staunch member of the BJP and also worked with the RSS, but more importantly, plies his wares as a lawyer. Aman Sinha ji, good to have you in the studio.
Thank you very much, Anand.
So Ram Lala brings us together.
My greetings to all the viewers. Jai Shri Ram.
We came together, if I remember, many years ago on this very case.
Yes.
And this has brought us back again together. Anand Ranganathan needs no introduction. I prefer to call him the Darwinian atheist, who is also a political commentator and author, and who believes Hindus in Hindustan are perhaps the 8th class citizens. His book is doing very well. Some great facts there. But when we talk about facts, and somebody who's endured Tarikh pe Tarikh, not just him, his father too, is Vishnu Shankar Jain. And with due respects and namaste to Hari Shankar Jain ji, Vishnu Shankar Jain, I'm going to start with you and please tell us, 1947 से पहले भी was this fight in courts?
See, the first case for this rights of the deity was filed by Mahant Raghuvar Das in 1885, and that case was dismissed by the District Court of Faizabad on the footing, and this is very, very interesting to note, the finding of the court was that yes, it is correct that Babur has demolished the temple here in 1528, but it's too late to remedy, and the British court said that we are not competent to rectify the historical wrong which was done by Babur in 1528. After that, the first case which was filed by the Hindu side was which was suit number 1, was by Mr. Gopal Singh Visharad in 1950, and he said that on Bais Bate, on 22nd and 23rd December, the murtis are there inside the so-called mosque, and the darshan and puja should not stop. And the District Court of Faizabad passed an order in 1950 itself, interim order, saying that the puja and worship should continue uninterruptedly, and there should be no, and the status quo should be maintained. So that was a very, very clinching point, and I would say it was a turning point in this entire case, and the role played by the then District Magistrate of Faizabad, Mr. K.K. Nayyar, and his passing of orders under section 145 of CRPC was very, very crucial and very, very important. And after that, the next very, very important date is 1st February 1986, when Justice K.M. Pandey passed an order for opening of locks of Ram Temple, and that was the, I can say and I can term it as the beginning of this entire Andolan. And this entire message reached all the Ram Bhakts that now you can go and worship there. After that, if you remember, on 6th December 1992, the so-called structure was demolished, and on 1st January 1993, Justice Harinath Tilahri passed an order that Ram Lala is a constitutional entity, Ram Lala is a constitutional deity, and therefore his worship and darshan should not stop. And that judgment actually made Ram Temple into Ram Lala deity shift into a tent. And from 1st January 1993 till 9th November 2019, all the devotees were worshipping Ram Lala in a tent. So I can just say very gracefully on your show today that we are coming from a generation where we have seen Ram Lala being worshipped on a chabutra, we have seen Ram Lala being worshipped in a tent, and today on 22nd of January we are going to see Ram Lala being Pran Pratishthit in a Bhavya temple.
But it's a chronology which is very interesting, but there are also gaps. Aman Sinha, why were there gaps? When did this matter first come to the Supreme Court?
Anand, let me start off by saying that the unanimous judgment of the Supreme Court was a historic landmark verdict. It was a momentous verdict, and it resolved the longest pending case in history of independent India. The case was initiated around 1950 somewhere, and it travelled through the courts, as my learned friend Vishnu was just explaining. Thereafter, from 1950 onwards to 2019 and then 2020, when the review was also dismissed, till that time, for 70 years, it remained the longest pending legal matter before courts, and it was finally resolved in 2019 when the unanimous 5 judges bench of the Supreme Court passed a unanimous verdict. Thereafter, Anand, I can tell you, not only it has been the longest pending case, but for 5 centuries this dispute was going on. So in that sense, it was the longest running dispute in past 1,000 years or so. And for Supreme Court to put a closure, amicable closure to all that, that also reflected judicial statesmanship and intellectual maturity of a very high standard. And it was commendable the way the Supreme Court judges came up with a unanimous judgment. And that also set a path, promoted unity, harmony, brotherhood in the society. And therefore, all appreciation for the unanimous judgment. In addition to that, but I would still like to add, Anand, and say, Anand, I'd like to add here and say that this battle of 500 years, about 3 lakh Hindu men, women and children sacrificed their lives. They gave supreme sacrifice for this cause. And it was not a fight or a battle for mere piece of land. It was a cultural, civilizational battle between 2 sets of values. One represented by barbaric values of Babur, who came and committed large number of atrocities, killed lakhs and lakhs of people and demolished thousands of temples. And on the other hand, the Sanatan, the eternal values which are epitomized and led by Maryada Purushottam Prabhu Sri Ramchandra, who even after winning Lanka, he did not subjugate it or annex it. He gave it to Vibhishan. That is the spirit of Vasudeva Kutumbakam. This was the contrast between 2 sets of values, and it's a remarkable day for all of us that in our lifetime we are going to see consecration of Ram Lalla.
We will say Pran Pratishtha, not consecration, because that is again in legal parlance. I would want to humbly correct you, because that land is already sacred. So it doesn't need to be consecrated. It will be Pran Pratishtha. So we should say Pran Pratishtha.
Ram Lalla.
No, Ram Lalla is Pran Pratishtha of Ram Lalla. Right. So let's agree to disagree there. But I'm just saying there were gaps, Vishnu Shankar Jain. When 2 sides go to a court and ask for a date, at least one side will push for a faster hearing. Were there times when perhaps both sides decided, let's just put it in abandon? No. Why was it so long? Why was it so long before I come to
4 suits were filed before the Faizabad Civil Court. Suit number 1, suit number 3, suit number 2 and suit number 4. In the meantime, suit number 2 was withdrawn. But when this matter, as I told you, on 1st February 1986, Justice K.M. Pandey, District Judge of Faizabad, passed an order for opening of the locks. It was a triggering point in this entire case, and after that the government filed an application under section 24 of the CPC before the Allahabad High Court, and they said that this matter is of national importance, so kindly do the original trial before the Allahabad High Court. Let me tell you, in Uttar Pradesh, the original trial of such disputes goes before the Civil Judge Senior Division, their appeal goes to the District Court, then second appeal to the High Court, and then SLP to the Supreme Court. So 4-tier system is there. But in 1989, the Allahabad High Court accepted the request of the government, and the original trial shifted to the Allahabad High Court for original trial. So can you imagine, for 39 years, the matter was pending in the Faizabad District Court and there was no progress in the suit. So when there was a big revolution in the country and they said that we need justice, and justice delayed is justice denied, the judiciary of the country intervened, the Allahabad High Court intervened, and in 1989, as per the provisions of the CPC, the suit was transferred. It's very rare of the rare cases where the Allahabad High Court will do an original trial of a case, unlike commercial disputes in Delhi and Mumbai, the commercial disputes go to the High Court for original trial.
Yeah.
But in Allahabad High Court, there is no such provision. So, exercising special powers under Section 24, the original trial of this case happened in 1989, and it is at that point of time a very good suit was filed by Devki Nandan Agarwal, which was ultimately decreed by the Supreme Court, which is suit number 5. And it was before that the devotees had come to the court. In 1989, for the first time, Ram Lalla came to the court and said that this land belongs to me. I am the owner of this property, I am the deity, and I must file the case through next friend, which was filed by Devki Nandan Agarwal. And ultimately, suit number 5 was decreed. So, there were continuous persuasion by the members of the Hindu community, the advocates, that this dispute must be resolved. And let me also tell you a very interesting fact. In 1992, there was a presidential reference in this case to the Supreme Court.
Wow.
And the question was that whether a temple, pre-existing temple has been demolished and a mosque has been constructed. That presidential reference Supreme Court refused to answer in Ismail Faruqi case and said that all these things will be decided by the civil court. It was then in 2002, it was then after that 10 years after that, in 2002, to find this issue, Justice Narayan of Justice Sudhir Narayan of Allahabad High Court passed an order for ASI survey, and for 1.5 years ASI survey happened in this entire.
So let me ask you this, and between Aman and Vishnu, please, Dr. Ranganathan, please. Bear with me. Because this is because 1992 you say that there was a presidential note asking the Honorable Supreme Court whether or not there was a pre-existing temple under that structure. Then you say that it was in 2002 that was an order. So 10 years.
10 years.
And let me ask you, both of you practice in the Honorable Supreme Court. Could the Supreme Court have decided that or not?
Anand,
could they have decided this in 1990? With due respect to all the judges, could they have decided this? Could they have answered the presidential note in 1992 or not?
Anand, sometimes judges are not the only ones who are responsible for delay or deferment of cases. What has happened in this particular matter, Anand, is that there was a large amount of indifference and negligence on part of some of the governments which were pursuing it initially. And therefore you have seen the impetus that it got after 2014 was remarkable. No, I am telling you what has happened. Now there are large number of documents, say for instance in Farsi, in Pali Prakrit. Nobody volunteered to translate them. It was the union and the state government which volunteered to translate all these lakhs of pages so that they could be relied upon as evidence. And therefore this was one of the primary reasons why it kept getting delayed. And the indifference of the earlier governments which was there was one of the reasons why it got deferred and delayed. Thereafter large number of parties, and then at different stages different legal questions come up of legal.
No, but Amanjit, see, I don't want to put you in the spot. But tell me, aren't there cases where the Supreme Court has intervened? It has overruled the lower courts and said this is what needs to be done. In this case, the president of the country is asking for an opinion and the court says, sorry, civil court will tell me.
Yes.
Is it palatable?
For me, it isn't. And thanks to my good friend Jay Sai, I have won the criminal contempt of court, so I can be a little bit more freer than I was probably 2 weeks ago. No, but Anand, to be very serious, a couple of points to be made here. And first of all, it's such an honor to be sitting next to, well, everyone here, but especially Vishnu. Every time I meet him, there is an aura and an energy that I can't explain that he transmits. So thank you. Maybe it's coming from you, of your father as well, Vishnu. So it really is a pleasure and an honor. Anand, I personally feel that we need to thank in no small measure the Islamist extremists of this country for the consecration or building of the Ram temple. Because had it not been for their protests against the Supreme Court Shah Bano judgment, had it not been Rajiv Gandhi and the Congress trying to appease them, the locks of Ram Lalla would never have been opened.
But that was a court order. Why would there be a political motive to it?
Vishnu is...
Pranam Mukherjee has written in his book,
Yes.
The Turbulent Years, page number 128, and I challenged it in the court. He said that Rajiv Gandhi की बहुत बड़ी गलती थी राम मंदिर का ताला खुलवाने की. I challenged it in the Delhi High Court, and I said, and you know who filed the petition? Petition was filed by Mr. Umesh Pandey. He said, on my petition, these locks have been opened. How can Rajiv Gandhi open the locks? So what you are trying to portray, that the Rajiv Gandhi called the honorable judges and get the locks opened. It was by the order of the court. Justice K.M. Pandey has opened the locks.
Under Congress rule, under Rajiv Gandhi and all, courts were independent.
Yeah, so that's what.
It is under the current disposition that the courts are being influenced.
The democracy has been sold out, and you know, we've lost the democracy of the institutions of Supreme Court. No. So anyway, I mean, you know, it's as they say, 6 of one, half a dozen of the other. The fact of the matter is there are 2 points I'd like to make. One is civilizational, and it is. Let me deal with that first. I think it's very unbecoming of our leaders to not recognize this as not a Hindu or a Muslim issue. It is a civilizational issue.
Correct.
It's got nothing to, you know. Our ancestors were hard done by. They demanded justice. They were meted out a historical injustice. For 500 years, 20 generations, they were forced to look at a mosque where a temple stood before 20 generations. And I just don't mean our ancestors, meaning ancestors of 1 billion Hindus, ancestors of 250 million Muslims, Indian Muslims as well. They are all the same. So for political parties, and I commend the BJP for taking this struggle up, and Shiv Sena as well. That must not be forgotten. Bala Saheb Thackeray.
Yeah.
And I don't know if any other party, Amanji, would probably illuminate me other than BJP and the Shiv Sena if they, you know, took forward this struggle. I doubt it. But I find it inexplicable that this so-called secular centrist parties did not take part in this struggle at all. What can be worse than that?
But abhi to Pranab Da ne kaha ki Rajiv Gandhi ne tala khulwaya. You said that was a turning point.
Well, I was being extremely cynical there, because he wouldn't have done it had he not wanted to appease the Hindus after he had appeased the Muslims. So it was a direct result of overturning the Shah Bano judgment. But coming back to the civilizational issue, and you've already called me correctly a Darwinian atheist, so I don't have any skin in the religious game. Let me put it, be very honest. But this is one of the most important matters as far as I'm concerned, as far as every Indian is concerned. So for Congress to say this is a Hindu issue, for Mulayam Singh to say it's not a Hindu-Muslim issue at all. And I want to extend that, because now comes the second part, which is the virtue signaling by the Supreme Court. I'm sorry to say this. Itself, and Vishnu would corroborate me, in the 2019 Ayodhya judgment, where was the need for the Supreme Court, I know you maybe are not in a position to comment, to ratify the Places of Worship Act, to say that this speaks great for our nation, this is going to protect the secular and fabric of our country. Where was the need to do that? That is, in my words, another appeasement, because the Supreme Court realized it's going to give 5-0 judgment in favor of the so-called Hindus, so it has to balance it out. And now disallow any other legal demand to reclaim a Hindu place of worship.
Why should it be? Because if there are 2 lawyers sitting here, you have gone through a certain legal process, and you would see that if you read the Places of Worship Act 1991, you would first look at it and say it should be void ab initio. It is bad in law.
I must criticize my dear elder brother Aman. He is younger, but he looks elder. That how for the last 10 years BJP has not abrogated the Places of Worship Act.
No, I can.
And nobody has challenged this in court.
No,
it's legal.
No, let me speak on this.
Do you not want Kashi? Do you not want Mathura, Aman?
No, I am responding to you, Anand. In fact, the Places of Worship Act has been challenged before the Supreme Court, and one of the senior counsels who argued this happened to be me. So I appeared for the petitioners there, and in fact on our petition, Supreme Court has entertained the challenge to validity of Places of Worship Act. It has issued notices also.
When did you challenge it?
This was just, I believe it was last year when the notices were issued.
9 years.
And I can tell you, Anand, that the large number, in fact one of the issues that I raised, it's a part of the Supreme Court order also, that intergenerational justice is a theme or a thread which runs through our constitution, and the atrocities, the all the barbarism which has been committed by by invaders on our past generations are going to be compensated. In fact, it was a case of there being no compensation. We were not even entitled to avail legal remedies in order to ensure that we are able to profess and pray to whatever our faith is. So now Supreme Court has, in fact, I can inform you that on authority, because I was the one who was arguing there. So last year itself, the Supreme Court has issued notices on this, and we are in process of completion of pleadings. It will come up for final hearing, but it is for the first time. No, that's because Places of Worship Act, as my learned friend Anand pointed out, you are also no less learned, and he accused me of looking elder. I don't believe that really. But after losing so much weight, maybe he's entitled to have a few banter on that. I compliment him on losing so much weight. So the fact is that Places of Worship Act is a very critical piece of legislation, in the sense that once the Supreme Court examines or assails its validity and sets it aside as ultra vires to the Constitution, if that is going to happen, then in that case large number of temples which were demolished, there is some data that about 40 lakh temples were demolished. So large number of such temples which were demolished, the Hindu Paksh will have right to reclaim those temples, going through the process of law.
Not just the right to reclaim, the right to reclaim those temples. You went to court on challenging Places of Worship Act. The Places of Worship Act excludes Jammu and Kashmir. Ever since the abrogation of Article 370, even before the abrogation of 370, to keep Jammu and Kashmir, Ladakh outside was wrong.
That is right, Anand. Actually, it was a knee-jerk reaction after the incident on 6th December. And
no,
this was a Narasimha Rao government creation, and therefore, in my considered opinion, also this is not going to withstand.
Let me ask you, Amanji. Let me ask you, and I'll ask Vishnu Jain the same question. When the farm laws came, look at the opposition to which had happened in courts. When the 370 abrogation came, when there are laws which were passed by this government, look at the challenge, CAA, how it was challenged in the courts. My question is, the opposition, political opposition of that day, when Places of Worship Act 1991 was done in a haphazard manner, in a hasty manner, was passed in Parliament, why didn't anybody challenge it? Why did they say it's okay to keep the erstwhile state of Jammu and Kashmir and Ladakh out of it? Why is it that even today, Jammu and Kashmir and Ladakh are out of it?
But I just want to make one small point, if I can. Look at the irony here, and Vishnuji would corroborate me on this. In fact, I learnt it from him. It is not the Hindus who have violated the Places of Worship Act. The Places of Worship Act, especially in Kashi, has been violated against the Hindus.
Correct.
So Vyas Parivar has been forbidden.
Yes, in November 1993.
Is that not violation of the Places of Worship Act?
It is.
They are accusing the Hindus of violating it. They themselves have violated it.
My point is, sir,
every
line, सुनिए, उसमें उस act में विष्णु जी, worship is unique only to the Sanatan Pratha.
Yes.
Jains, Baudh and the Hindu way of practicing faith, they do worship, the rest pray. So word worship and pray cannot be equated. It has been nicely equated. It has been equated there. Then 15th August 1947, religious character of Gyanvapi was what?
People tree kata, sacred people tree kata, Hanuman ki murti hataiye,
Ganesh ji ki murti
is that not violation?
So then Shringar Gauri
puja kar rahe hain, just like Jews in Jerusalem.
So nobody, why didn't anybody challenge it, Vishnu Jain?
See, I'll just tell you, first of all, in 1991 this draconian law was passed. And in Ram Mandir case, I would agree with Mr. Anand Rangnathan that the Supreme Court, and let me tell you with lot of sense of responsibility, in this 42 days of hearing before the Supreme Court, there was not even a whisper of argument by both the sides on the validity or question of Places of Worship Act.
Correct.
Places of Worship Act was not even argued by the members of Muslim community, by the
so judges को wisdom कहीं से आया? Allahabad High Court 2010 judgment में भी किसी judge का
Justice Dharamveer Sharma had commented upon the Places of Worship Act. It was an arbiter verdict, and that arbiter was set aside by another arbiter, which was the judgment of the Supreme Court. But can you appreciate one very interesting part? Under Section 5 of the Places of Worship Act, Ram Mandir was exempted. So when the Ram Mandir entire dispute was exempted by the act itself, there was no question of entering into that validity of the act in Ram Mandir case. Because section 5 had exempted Ram Mandir dispute. So it was unfortunate for the Allahabad High Court to comment upon the validity of Places of Worship Act in 2010, and that arbiter finding was again set aside by another arbiter finding of the Supreme Court.
Correct.
But the point is this here, this be that as it may, I am definitely criticizing the judgment of the Supreme Court because reasonable criticism is welcomed by the Supreme Court itself. But I would also
Dissent
appreciate...
is the safety valve of democracy.
Yes, but I would also appreciate one very interesting thing. I have mixed feelings on the judgments of the Supreme Court. See, if you will examine the dispute of Jerusalem, from past 2000 years, all the three Abrahamic religions who have given us the word secularism, they are fighting for a 35 acres piece of land, which they all believe is sacred to them.
Yeah, the most contested piece of land on the surface of the earth.
And the entire world judiciary, the United Nations, all the big nations of this entire world have not been able to solve that dispute. But it is the strength of Indian judiciary that even after 69 years we are able to solve the Ram temple dispute, and both the parties have agreed to it. We may differ with the judgment. I also differ with the judgment. I have my lot of reservations with the judgment. I still believe that the 5 acres which was given to UP Sunni Central Waqf Board was erroneous. I was one of the Hindu parties to file a review before the Supreme Court. Out of 12 reviews, 11 reviews were by Muslims and 1 review was by me, that this 5 acres which have been given as an alternate land is erroneous. Because ultimately what Babur did in 1528, it cannot be compensated by 5 acres of land. But be that as it may, the judgment of the Supreme Court has come, we agree with it. But I'll tell you something very interesting. The very interesting feature of this case which nobody talks about it, and if you closely examine the judgment of the Supreme Court, from and Anand, I would request you that if ever you get a chance, please ask this question to anyone who says that this judgment was on Astha. ये तो आस्था के आधार पे फैसला दे दिया ये कहते हैं. I'll just give you some very important facts. From 1528, and this is not me saying, it is recorded in the judgment of the Supreme Court. From 1528 till 1855, and it has been admitted by UP Sunni Central Waqf Board, there is not even a whisper of offering namaz at that place. They admitted before the Supreme Court.
So nearly 325
years.
25 years.
325 years from 1528 till 1855. No evidence, no document, historical or oral, to show that they were offering namaz there.
And it's part of the judgment.
It is part of the judgment. Supreme Court, this has weighed for the Supreme Court to give suit number 5, to decree suit number 5. Plus another subse important event in 1510. Guru Nanak Dev had visited Ram temple. Yes. He had took bath in Saryu river and offered worship at Ram temple. 18 years before demolition. After 1528, the very first document which you find is 1592. Aine Akbari, Abul Fazal, Akbar's own court master, who writes that Hindus are worshipping here. After that, the travelers come, Tryphentheller, Buchanan, Martin, Montgomery Martin, Carnegie, everyone has written that there are 14 जो अभी आप प्ले कर रहे हैं, 14 कसौटी के खंभे हैं जिसके लोग हिंदू पूजा कर रहे हैं. यहाँ पे बराबर हिंदू समाज के लोग राम मंदिर और रामनवमी को पूजा पाठ करते हैं. ये सारे ट्रैवलर्स ने लिखा है. And then the report of the ASI comes. You know what the ASI, they say that जब मंदिर तोड़ने का कोई प्रमाण नहीं है. Please ask them to read 2021 SCC page 1, paragraph 730.7, where the ASI's finding has been approved by the Supreme Court. And what did the ASI say? That जो नीचे structure मिला है, that is non-Islamic.
Yeah, it's a Vishnu temple also.
And this temple is of 12th century.
Hindu origin.
Yes.
So there is a very important point to be added here, that apart from the 5 judges unanimous judgment, there is an addenda to the judgment. Now that addenda goes on to say that it has actually recorded that particular place is the birthplace of Prabhu Sri Ramchandra. This is what all our past generations were fighting for, and it has arrived at that conclusion based on legal principles, based on evidences of faith, not only of faith but of worship through the centuries. And therefore that very landmark part of the judgment, very critical finding of the judgment, sometimes there is not too much discussion on that, because we were not fighting merely for a piece of land, but the Supreme Court has arrived at a conclusion that that is based on evidences, large number of testimonials, large number of historical scriptures which were there. For instance, the one, the visit of Guru Nanak Dev. And there are large number of such
No, even that stone inscription that was found, the KK Mohammed
based on that,
you are talking about.
therefore based on the legal principles, Supreme Court has arrived at a conclusion that this is indeed the birthplace of Prabhu Sri Ramchandra, and therefore right to build a temple and right
tell
to
me
worship.
something, Amanji. You wanted to say
Yeah,
add that, and then I'll come back to you, Amanji.
Yeah, no, I wanted to say something important because I think this must not be lost in this wonderful discussion we're having. The very nature of the state that encourages not just Hindu phobia but Hindu misia, which is active, not fear of Hinduism, hate of Hinduism.
Misia is hate.
And you don't have to, it's not visible in the 2019 Ayodhya Supreme Court judgment, but you look at the Allahabad High Court judgment on Ram Temple. Historian after quack leftist historian said that there was no temple underneath. Historian after historian. Allahabad High Court on reference, on point has blasted each one of them, has exposed their perfidy. People like Irfan Habib and so many other, I don't want to name because it sullies the whole atmosphere. I can almost smell sulfur here. They were saying that the Vishnu, the relief was stolen from the Lucknow Museum and brought there to show that they were idols and other reliefs excavated by people like Bibi Lal and KK Mohammed there in 1976. Such lies. And why does this happen? Let me now quote Babar verbatim. For the sake of Islam, I became a wanderer. I battled infidels and Hindus. I was determined to become a martyr. Thanks be to Allah, I became a Ghazi. These are words of Babar from Babar Nama. These were the kind of people that the leftist quack historians have been eulogizing. Now you tell me, what does a Hindu do? The Hindu at least would legitimately like to approach the court. My lord, you may give a verdict against me, but how can you stop me from asking for the verdict? This is what the Places of Worship Act does.
Just adding on to that very important point, because there is a remarkable contrast here. The legal principle is that intergenerational justice has to be compensated in the future generations. What has happened here on the contrary is that injustice was perpetrated upon us, as Anand pointed out, and after the constitution came into being, after we became independent, now the Places of Worship Act, because it is effective retrospectively from the day of independence. So from that particular day itself, whatever is the nature of a monument, you cannot even avail your legal rights or agitate or assert them to ensure your right to worship. So though intergenerational justice has to compensate future generations, in our case, we faced atrocities, we faced barbarism even before independence. I mean to say the Hindus at that time also, because there were Mughal rulers, and after independence the Places of Worship Act goes on to put a statutory bar that Hindus cannot avail
this
their
is
legal rights to assert their
See, in
right to
everybody's
worship.
wisdom, when you read it, you know that this is done as virtue signaling or a compensatory manner by the parliament of the country. But the courts of our country are supposed to uphold the law, and everybody is supposed to be equal. You are senior advocate in the Supreme Court. You have fought so many cases. You have just gone through the entire. My point is, how is it that the courts didn't take suo moto cognizance of this, sir? Why is it that the courts had to insert Places of Worship Act into this? Why are the courts trying to virtue signal only on certain matters? On the other hand, then they want to talk about everything else. At that time, there is no virtue signaler, let's do balancing. Then they want to take a clear-cut position because they want to hog the headlines. Am I incorrect in saying this? Am I being disrespectful of the courts if I say this?
I think you're asking two lawyers that, so they might not be as open as I am.
No, it's all, I can respond because I initially told you also that as far as Places of Worship Act is concerned, the constitutional validity of the Act itself is under challenge by no less than Supreme Court. The notices itself have been issued, and because I am appearing in that matter as a senior counsel, in fact, the Chief Justice has formulated two questions that I have put.
No,
but what I was saying,
Places of Worship Act is okay. That we are all making certain points, and which is there in form of the inter courts. Why are the courts sitting on it for such a long time is another question. Secondly, when they write the judgment, aren't they not aware what they are saying? On the one hand, you are saying we uphold in the addenda, like you mentioned, uphold the ASI survey.
And 10 seconds.
That this structure was un-Islamic as per the tenets of Islam. It's also part of the judgment. Then why go ahead and do a certain...
What happens?
Just 10 seconds. I want to add to that because it's very important. You see, the case of Babri, you can say that it could have gone one way or the other. Of course, it was a title suit, but the fact is you could not see the temple there. So somebody had to prove that a temple existed, and so many archaeologists did that with so many other modern scientific equipment. So you could have, it's contentious. I want to ask the honorable courts, what is contentious when you can see the half demolished Kashi Vishwanath temple and the Gyan Vyapi mosque domes on it? What is contentious? So I ask you, as a representative of the government, Amanji, what is stopping you from, basically taking this case forward? That this is unlike any other case. You can see the demolished temple.
The idea is not to put you in the spot.
No, it's all right.
इसमें कहावत है कि प्रत्यक्ष को प्रमाण क्या? If you are the witness, you can see it in your eyes. Why do you have to need any proof there? Are you trying to say that the honorable judges of the Supreme Court can't see it beyond their courtrooms? They don't know what is evident there. Now, had this been reverse, what would have been the reaction?
Well, Anand, all said and done, let me tell you that this was a contentious issue, Ram Mandir itself. But Supreme Court did come out with a judgment, and not that to a unanimous judgment on the point. So legal processes, and obviously, wherever the role of state and central government comes in.
Were the courts ever influenced by politics or not?
I do not think so.
Not just the Supreme Court. At all levels. District Court.
I do not
39
think so.
years in Faizabad Court. Why was it then stuck if it was not influenced?
No, it is for those parties and
why
those
would a
people
former
to
president write in his book
I have told you
the
one
Prime
thing.
Minister के कहने पे खुल गए ताले?
I am telling you one thing, Anand, that is not how courts are supposed to act or function.
And they are not supposed to function like that.
Yeah, that kind of delay, obviously.
Influenced?
But delay, you have to get into the depth to find out what is the exact reason for the delay. And I have told you one of the primary reasons have been that the governments were not diligent and meticulous in pursuing the litigations, and that is the remarkable shift which happened after 2014, as I was mentioning to you, that it was regularly pursued before courts of law, whether it was a question of getting stuck at translation of something in Farsi or Pali Prakrit and all those historic documents. All that was done, in fact, volunteered by the union and state
congratulations government. To BJP for doing that, but मुझे George Orwell का एक quote याद आ गया. In times of universal deceit, just speaking the truth is considered a revolutionary act. This was your job. This is the government's job.
We are not saying that we did any great service. I am saying that this is what should have been done earlier. Sir, then this delay would not have been there.
I'll come back
that
to
is the point that
I want to tell some untold stories of Ram Mandir. We are discussing about Ram Mandir. So I want to tell certain untold stories about Ram Temple. One very interesting thing, we are talking about the judiciary and influence of the politicians over the judiciary. I strongly believe that judiciary of this country is very strong and they cannot be influenced by any other power or any other you can say segment of the constitutional regime. But the point is, let me give you an example. On 1st February 1986, as I told you, Justice K.M. Pandey ordered for opening of locks. In those times, the practice was that if a district judge has to be promoted to the High Court, the file goes to two places. One to the state government and other to the Chief Justice of the High Court. And both of them have to give their marks or their remarks on the file. Will you imagine, Anand, Mulayam Singh Yadav, and I am telling you on your show today on authority, Mulayam Singh Yadav was the Chief Minister of Uttar Pradesh. When the file of Justice K.M. Pandey went to him, and I am telling you verbatim what he wrote, Justice K.M. Pandey बहुत ही ईमानदार और निर्भीक न्यायाधीश हैं, पर चूंकि इन्होंने राम मंदिर के ताला खुलने का ऑर्डर किया है, मैं इनके नाम की संस्तुति नहीं करता हूं. I don't recommend his name for promotion to the High Court judge. This was the note of Mulayam Singh Yadav, and it is on affidavit. I am telling you on your show. Apart from that, this is just one piece of it. In 1990. Car sevaks were killed and the government did not give compensation to the car sevaks. Forget about compensation. They did not even agree on the total numbers of car sevaks who actually were killed, brutally massacred. They said that 16 have been killed in the firing, while the number was much more than that. And writ petition was filed in 1990 by my senior Mr. Harishankar Jain saying 362 people have died. Please go and have a commission into it. Nothing was done. Then apart from that, I'll tell you on your channel today, in this Ram Mandir case, one minister who was the revenue minister of Uttar Pradesh did interpolations in the revenue record, and in the revenue record जहां पे लिखा हुआ था जन्म स्थान, उसके ऊपर interpolation करके लिख दिया मस्जिद जन्म स्थान. मस्जिद वर्ड ऐड कर दिया गया. So all these things were done, and for 10 days in Allahabad High Court we argued on revenue record that there are interpolations in the revenue record. So all these things were done, and let me tell you, on 9th November 1989 जो कार सेवक थे उन्होंने वहां पे कनोपी लगाई थी, छतरी लगाई थी 9 नवंबर 1989 को. द मुलायम सिंह यादव गवर्नमेंट उन्होंने छतरी कटवा के फेंकवा दी वहां पे 9 नवंबर 1989 के बाद. Allahabad High Court we filed a petition and said that there was a chhatri. The government said there is no canopy, no chhatri, and the commission went, advocate commission went, led by my father, और वहीं से छतरी बरामद कराई. So इस तरह का काम, ये untold stories है राम मंदिर की.
So that means you are saying politicians.
Let me make a quote here.
Those who are actually with their surname Yaduvanshis.
Yes, they have done it.
They were trying to tamper with evidence, is what you're saying.
Yes, they have done it, and I'm telling you all these things. It is not my version. It is records of the court which I'm telling.
And so Anand, just a quote here. Quote: my direct order to fire. My direct order.
He was referring to SP government. Just let the record be straight.
Yes, I'm referring to SP.
My direct order to fire at the car sevaks on October 30th, 1990. Was needed to save Babri Masjid and maintain the faith of Muslims in our country.
Correct.
Even if 30 people had died in the firing instead of 16, I would still have not withdrawn my decision. Unquote, Padma Vibhushan Mulayam Singh Yadav.
I filed and you know, Anand, after this statement, I lodged an FIR. FIR was refused to be registered. Till the Supreme Court I fought. No FIR was registered. Let me tell you, if a sitting chief minister says that I ordered firing on a particular community for a particular purpose, can you say, is it not massacre? Is it not massacre? Nothing was done by the judiciary or by the system of this country.
But it's the same courts that
something was done by the system. Padma Vibhushan was given.
No. Weren't the same courts listening to or hearing the matters pertaining to Gujarat? Weren't
Exactly,
the same
that's
courts
my
pertaining to
question.
Gujarat under the
my
now
question.
PM, the then CM Narendra Modi? And you're saying that the same courts took a different view of statements or actions done by in another state by another chief minister.
Forget about different view. They dismissed the SLP asking for registration of an FIR with CD. I had annexed the CD of statement of Mr. Mulayam Singh Yadav that he has admitted firing on car sevaks for a particular purpose which Anand Ranganathan has just quoted.
Is it also true that one of the judges who was part of the Allahabad High Court 2010 judgment had some notings which were made? Would you want to share it today? Is it true?
See,
those notings?
I'll just tell you, there was an objection during the Ram Mandir hearing. I'll also tell you, Justice Rafat Alam was heading the bench in Ram Mandir case, and my senior Mr. Harishankar Jain on affidavit filed an objection before the honorable judge, and he said that Justice Rafat Alam is a relative of Shayyad Sahabuddin, who is a leader of Babri Masjid Action Committee. It's a well-known fact. And if you are a relative of Babri Masjid Action Committee, the judicial proprietary demands that you do not.
You recuse yourself.
You recuse yourself. It was not, sir, please appreciate this. It was not accepted by the honorable court, and we were you can say एक कोने में अलग थलग कर दिया गया था. Same point. Mr. Rajiv Dhawan argued before the Supreme Court, and he told Justice Yuju Lalit that you cannot hear this matter. And if you remember, initially the Supreme Court bench was constituted of 5 future Chief Justices.
Yes.
And then the bench was reconstituted, and Justice Yuju Lalit had to recuse himself. So all these things have happened in this case.
No, but it just then points out to one aspect where the independence of the entire process of the judicial system then comes under a cloud. And is it done because it was pertaining to Ram Lalla and Ram Janmabhoomi? It was because of the Hindu faith in Hindustan, Aman Sinha.
Anand, let me tell you that I do not believe at all that independence of judiciary is under cloud in any manner whatsoever. You are right, legal processes sometimes, being procedural, they can take time, and but as long as, obviously we all need to speed up. For instance, you've seen large number of legal reforms coming in on Prime Minister's initiative. More than 2,000 obsolete legislations have been scrapped. More than 40,000 burdens and compliances have been removed. And similarly, new criminal law amendments, enactments have come in. So large number of steps are being taken by the government. You are right that in judicial processes, and we are all stakeholders of that. There are lawyers also who are there, who are appearing. There are people who are parties who are there. So there are large number of issues, large number of
No, no.
reasons
See,
due to which there might be delay. One of the reasons was, when a senior counsel argued that no, let this matter come up after 2019 elections, because otherwise, it might provide some electoral benefit. So all those, kind of reasons, I don't think this should really cut ice before the Supreme Court, and in fact it did not. So I do not agree that Supreme Court's or any court's independence for that matter is under any cloud. You are right that legal system, legal processes, it takes time. It is duty of all of us to speed it up, and I can assure you that this government
what I am trying to tell you,
if I can respond,
are you convinced, Aman Sinha ji, that the time that it has taken, are you convinced, Anand Ranganathan, that there is no political influence in this case?
I was
no
just about to
external
corroborate
influence in this case?
and rebut my dear friend Amanji when he says
And
that
depending upon how much
judiciary
clout
is-
you wield in the court,
Yes.
you can go ahead and influence
I wanted to just-
or perhaps somewhere way in over the bench.
As I said, without being patronizing, because both of them are members of the court and honorable lawyers, but I want to say something here. Both, I think Vishnuji and Amanji would have heard of Justice Baharul Islam. Just to corroborate and rebut Amanji. Okay, let me give you the antecedents of Justice Baharul Islam. As a congressman, he was elected to Rajya Sabha in 1962, re-elected in 1968. He resigned from Rajya Sabha in 1972 to become a Guwahati High Court judge and retired in March 1980 to return to active politics. 9 months after retirement, the Indira Gandhi government appointed him as a judge in the Supreme Court in December 1980. He resigned in January 1983, weeks after he gave a verdict favouring Congress's Bihar CM Jagannath Mishra in a corruption case to contest the Barpeta Lok Sabha seat. The elections were countermanded. Nonetheless, Congress saw to it that Justice Islam made it to Parliament by nominating it to Rajya Sabha in 83 for 6 more years. You still say that there is no mixture of politics and judiciary, Amanji?
No, Anand, you have said what you have said. I don't have anything to add here. But I can just tell you, no, it's not a matter of laughing or anything. I can just tell you that what is of critical importance is that when you come to bench, you are able to dispense justice. And I am not taking any side or supporting anyone. And but what I am saying is that once you come on the bench, and then the manner in which you decide the cases and you dispense justice, that is what counts. And obviously what people expect from judiciary or courts is to have some amount of consistency, some amount of uniformity.
Educate me. Under Atal Bihari Vajpayee ji, there was a peace committee that was formed. The solution at that time was give this land to Hindus and take 5 acres. This was in the 90s. How is the 2019 judgment any different from what was decided then?
No, judgment would be different in several respects. But obviously,
net अगर ये समाधान उस वक्त हो गया था,
नहीं हो सकता था आनंद, because
not
an inch would be given.
This agreement
Every inch has to be fought in this country. You know that.
So
Hindus wanted to celebrate Ganesh Chaturthi. They asked for 24 hours to be given Waqf land. They were refused. They had to go to the court.
See,
alleged Waqf land. The alleged Waqf land.
However it was, all sides have the right to go to court, Vishnuji.
Yeah.
Did you at any point say that, had it been, I am not going to get justice?
No, actually.
Or what point did you feel कि यार finally जाके इतना लड़ने के बाद किसी तरह से हमारी अर्ज सुन रहे हैं, प्रभु भी नहीं, courts?
No, actually I'll very honestly tell you that this entire battle of 69 years has been a battle of extreme patience on behalf of the members of the Hindu community. If you remember, the matter had travelled to the Supreme Court. Initially, the Supreme Court said that this is not an important matter for us. And ultimately, all the members
the court had said this. I was about to come to you. That the top courts of the country had said it's not an important matter.
It's not an important matter for us, and ultimately, all the members of the society decided, and they urged the Supreme Court to hear it expeditiously. And it is after all that sentiments and after all that applications were made in the Supreme Court from 2nd of August 2019, the day-to-day hearing in this case started, and even the Supreme Court heard this matter in on Saturdays also, which is not a normal culture in the Supreme Court. This is the second longest
When
hearing.
the courts want, they'll wake up at 5 a.m. in the
Yeah.
morning also,
So this is
or
the-
they will have
yeah.
a bench during the vacation
this is
also.
the-
They will
This
come.
is-
has already
they-
escaped conviction.
This is
Another
the-
Anand wants to be convicted.
I am stating
Kya
facts,
kar-
sir. I am stating facts.
This is the
I am not
second-
making things, drumming up things from, or it's not figment of my imagination. Is it true or not that the court sat at 5 a.m.? Is it true or not that a bench was sat when the court was in vacation and on a Saturday it was done to grant bail to somebody?
Yeah.
It's true. It happened, right? Yeah.
So I was saying
I'm
that
allowed
after-
to state facts.
Yes, after the Keshwanda Bharti case, this was the second longest hearing. So we have our own criticism against the Indian judiciary, but at the same time, it's whatever I've stated today before you on your television. It's hard facts. And it's not that I am saying it in the manner of criticizing the judiciary or appreciating the judiciary. These are facts of the case. These are glaring facts of the case. If a member of a bar has asked a particular judge to recuse, it's not Vishnu Shankar Jain who is saying it. It is there on record. If a member of the bar has torn the Naksha of Ram Mandir
Yes.
before the 5 judges bench of the
Yes.
Supreme Court,
Can
and
you
no
imagine?
contempt was taken
Yeah.
against him. It is not me who is saying it. It has happened.
It has happened.
मिस्टर राजीव धवन ने राम मंदिर का नक्शा 5 जजेस के सामने फाड़ के फेंक दिया. क्या ये, मैं उससे ज्यादा नहीं बोलना चाहता हूं, पर मैं आई एम जस्ट सेइंग दीज आर हार्ड फैक्ट्स एज मिस्टर अमन सिन्हा हैज टोल्ड.
No, would the reaction have been same had an Aman Sinha or Vishnu Jain have been done? Would there have been equanimous observation or noting of the behavior, or was it influenced by different individuals?
Of course not. Had Vishnu torn the Eidgah map, he would still be in Tihar.
So I just want to say that is lot to learn from this 69 years of legal battle. We are still members of
I
the.
have to wind up, but I quickly want to know, when was it that you got a sense that there is closure going to happen, especially in the courts?
See, from when the 5 judges bench of the Honorable Supreme Court started day-to-day hearing, when they used this term that we are going to do day-to-day hearing of Ram Temple from 2nd of August, I had a feeling that there will be a quietus to the dispute. And the way the hearing went on for 42 days, and I felt that it will be solved. And when Justice Gogoi reserved the judgment, and he said that it will be miraculous that in 40 days we will give a verdict, I had a feeling that it will be resolved.
It will be resolved. But Amanji, could the Hindu Paksh have been more united in its approach in the courts? Because there were varied suits, many suits. Could there have been a more cohesive representation by the Hindu Paksh? Final question, 30 seconds, I have to wind up.
No, I believe initially there were large number of suits, but later on when it came to appearing before the Supreme Court, there was some amount of coordination and cooperation also, and we put up a united front. I also had the opportunity to appear in the matter as a senior counsel, so I can tell you that. But all the matter of great satisfaction and pride and a joyous moment for all of us is that after this long battle, sacrifices of generations of people, about lakhs and lakhs of Hindus laying down their lives, today that pious moment of consecration or pran pratishtha of Ram Lala Virajman at Sri Ram Janmabhoomi Mandir is coming through on 22nd of January, and it's a matter of pride and joy for all of us.
The point is that Ram, Shiva and Krishna have to show so much of patience to get what is due to them in Bharat. So then all of us are mere mortals. We need to show so much more patience, and we need to continue to persevere harder. Dr. Ranganathan, you want your 10 seconds? And
Yes,
close it out for us.
I
please.
just want to say there is a reason why I love this country. It is because the majority population in this country, 1 billion, left it in the hands of just 5 people to decide the fate of the most sacred of places. Which other country, which other religion will people belonging to those countries and religions do this?
True. And that's why we are Bharat. Thank you very much,
came up with a
gentlemen.
unanimous
Fantastic.
judgment.
I'm way over on the show, but it was a phenomenal conversation. Thank you to all our guests. Thank you very much. Thank you. Namaste.